U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. And boy, do I have a good one for you today. So, next to how long does this process take? How long does it take to get your green card in the marriage base, in the employment base? That's the most common question I get. The next question that I get is, my green card process is taking too long. Is there anything I can do to get the process to go faster? So I'm going to talk about some of the steps that may be available, that you would may be able to take in the case that your process is dragging on for very long. So in the United States, when you are applying for each process, so let's talk about the green card through adjustment of status, you do have a processing timeline. The processing timeline it differs based on different service centers. And no, you cannot just decide to apply to a service center that is faster. That decision is not yours. It's really based on where you're living. It's not based on the state, well, it's based on the state, but it doesn't mean that if say, Vermont service center is faster, and you live in Vermont, that you're going to file it in Vermont. It doesn't necessarily mean that. But you do have a group of states. If you're living in a certain group of states, then you apply to one location. If you're in other states, you apply to another location. So you have to be careful about where you're filing your petition. So that's just one side note, is that you can't control, though, which service center you get to file, because one may look like it's going faster than the other. But wherever you file it, you can see what their processing timelines are. And, when you look at their timelines and say it is going from 6 months to 36 months, that means that the shortest application there is about 6 months. The longest has been going on went on for 36 months. And yes, that is happening in certain locations. So the first thing you have to do is, when you're thinking about how you can move your process faster, you have to understand what your processing time is at that specific location where it is. You have to be able to see if it's the range of time is 6 months, for example, 6 months to 36 months. Then the bad news is you have to be beyond the 36-month period before you can submit an inquiry, a case inquiry to the USCIS. A case processing inquiry would be able to allow them to research. It basically prompts them to look into your matter and be able to get it moved along faster. So that's just the downside, is if that particular center takes very long to do the applications, it means that the inquiry, you should not be submitting the inquiry. And if you do submit an inquiry, you're going to get the same answer, which is usually that is not outside of case processing times, and you can submit your inquiry after the time has passed. So in that case, you're not necessarily going to get far with that. And it means then, another thing it means, though, is that even though it may be taking long for you, it's not out of the ordinary. Your case processing time isn't out of the ordinary than anybody else's. It means that you're right there in the boat with a lot of other people who have to be waiting for this length of time. Now, me personally, I have never seen my adjustment of status applications go longer than this, longer than 36 months. I think it's pushing it. But that is the extreme time that they have, and you would have to be able to submit the case inquiry outside of that time. There are other ways to be able to bring this to the USCIS's attention, and getting a congressperson in could also benefit you here, especially if you're maybe experiencing an emergency or some sort of urgent humanitarian crisis where you need your process to move faster. So if you, the really and truly, you shouldn't be submitting any kind of prompts to get them to move it faster unless you're outside of the case processing times, or you're experiencing a type of situation that warrants your case to be moved faster. So, for example, if you are in a situation, say, um, your relative, say in the marriage based situation, your relative is experiencing health issues. The relative who is, or the spouse who is sponsoring you, is experiencing a medical crisis. They're unable to work, so they're facing economic loss on top of that. And the only way that you're able to then help them is to be able to get your process move faster. That may be an argument. It may be an argument for a work permit to be moved faster, but may also be an argument to push your permanent residence forward faster. They may just approve an expedite request. So these are done through expedite requests, and they're submitted to the USCIS. So if you're experiencing a crisis or some sort of situation that's outside of the ordinary, and getting your permanent residence is going to make a difference for you or your relative, then that could definitely be put forth to the USCIS. Another is, what if you're going through the employment-based permanent residence process, and you say your employer desperately needs you to be able to move forward, get your status. Um, okay, Yeah, so your employer desperately needs you to move forward to get your status because they themselves are experiencing a shortage of employees, and because of that, they're experiencing losses as well in their revenues. In that case, the employer can assist you to be able to get your process to be moved faster. A lot of times as well, these arguments that I just brought up are also good to expedite your work permit. So even if at this point your permanent residence process still has to continue on the same processing timeline, if you don't already have your work permit and your social security number, then at that point, submitting information like this regarding health, a humanitarian crisis, economic loss, and showing also that you work in the medical field, or that you work in the medical field, or that you work in childcare. Those can also help you to move your process forward faster, specifically the work permits, because they have issued guidelines stating that work permits can be moved faster in the case that you do work in healthcare, you work for childcare. Uh, all right, so it seems a little glitchy, so just let me know. Okay, no sound. Okay, all right. So I'm gonna come out and then I'm just fixing an issue here. All right, so I am back. Okay, so I had some issues here. Now I'm back. So I was talking about ways that you are able to speed up your process in the case that you are facing some sort of situation that's outside of the ordinary. The sound got lost, the audio got lost on here, so I'm logging in. Just let me know. One or two of you can just let me know whether you can hear me. So the last part that I left off before we had the technical issue was the fact that if you look at the service center, this information is available on the USCIS website. And if you look at the USCIS website, case processing times, you look at where this, oh, thank you so much for letting me know. Thanks so much. And if you look at the service center that's processing your case, you look at the length of time, their processing times, you'll be able to tell whether the processing times that you're experiencing is out of the ordinary. For example, I use say you look at a service center and it has 6 months to 36 months. That means that the shortest they've processed is 6 months, the longest is 36 months. Doesn't mean yours is going to be 36 months. But in that case, if you're still within that period of time, you haven't gone beyond the 36 months, then you do have to wait. You can always submit inquiries, but if you submit inquiries at this point, this may even delay your process because they're busy pulling it out of queue to review it, to be able to answer your inquiry request. Another thing is that um, they will just say you're still within case processing times. Please submit your inquiry after that time has passed, or even if that time has passed. So in that situation, it's a process and you may not get very far with it unless you're outside of that time period. Doesn't mean though that you can't request that your process be expedited if you're experiencing a situation that's outside of the ordinary. So, for example, if you're experiencing an urgent crisis or humanitarian crisis or a medical crisis, if your relative or your employer is experiencing severe economic loss, that can also count here. And then in the case of the work permit, not necessarily for the process, but in the case of the work permit, they are expediting work permits for healthcare workers as well as childcare workers. So in that case, even if you don't get your permanent resident process move forward, but then you do have you want the work permit and social security number as soon as possible so that you can assist the household in working, then you could submit an expedite request based on those pressing circumstances that you're experiencing. These are some of the things we do for our clients in the case that they are experiencing urgent or a humanitarian crisis like this. We do, step in and help our clients to request these expedite requests. Now, these are discretionary, and you do have to submit evidence of whatever is happening. So you can't necessarily say this is happening and then think they're going to approve it. Sometimes they do. Sometimes that does happen, but you better be prepared to submit the evidence to show that you're going through this. So, for example, if it's the employer who's experiencing economic loss, and a letter from the employer is going to be good. If if you're a relative or you are experiencing some sort of crisis, then so medical crisis, for example, then a medical record showing this can also assist the officers to make a determination in your favor. Now, what if this doesn't work and you really do need to get your process moved forward? There are other tools that we pull out of our bag when we're working with clients who are dealing with an urgent situation. There is the ombudsman, and the ombudsman is the person that is at the USCIS who helps to resolve problems like this. For the ombudsman, usually the ombudsman does want to see the case processing times outside of that you're outside of the case processing times. But then surely if you do present a crisis that warrants the expedite request and it was denied by the USCIS, you sought it and it was denied, then the ombudsman could be a great agency in the USCIS to help to push things through, and to give it a second look and then advocate for another result if they believe that's warranted. So the ombudsman can definitely be a good partner in assisting with issues like this. Different issues that come up, problems with the USCIS. The ombudsman could be that unbiased agency that can assist with moving your matter forward should they see it fit to do it. So they usually review everything and they determine how they're going to move forward, if they are going to go ahead and submit an inquiry to find out more, or if they're going to decline that. Then there's also contacting your congressperson. So the congressional, they they submit a request on your behalf, asking maybe for the reason it's taking so long, and then if you can provide the congressperson with the information they need to advocate for you further, if it's urgent, you would provide that information to the congressperson, and it's going to be in your district. So it's going to be where you're living. You're going to contact that senator or that representative, and the representative, they do review what you are requesting, and they will then assist you should they also see it fit. They usually start with inquiring, especially if you're asking why is it taking so long. They will inquire into it, especially if the USCIS is not being very transparent. The USCIS usually responds and explains to the representative or congressperson why it's taking so long, or if you need it expedited, they can assist to get the matter expedited if there's an urgent need to do that. So these are different tools that can be used to escalate your matter and to be able to get your case moved along faster. But these are not tools that we use on a day-to-day basis for our clients. We use it sparingly, just because we understand that it's not all going to be approved. And in addition to that, clients, these are for clients that are going through an urgent situation, and it's warranted. So this is not something that you just do because you want it done. You want your case pushed forward, so you submit this. That's not how it works. This is usually done in cases where it's warranted. It's either taking way too long based on the processing times, or you're experiencing a situation where you need your case expedited, because it's either regarding life saving, is helping you save a life or save your own life or improve your medical condition or somebody else's medical condition or your economic situation. All right, so I'm done talking about some of the tools that we pull out of our bag for our clients when they are in a situation and they need their matter pushed forward. Now I am going to answer questions. So go ahead and put your questions in the comments, and I will go ahead and answer. All right, so I see a number of questions. So let me just go through. So after VAWA biometrics, how long it take to get a work permit and travel documents? So I don't usually count from the time of biometrics because biometrics are all over the place. What I would say is from the time of filing, I'm seeing anywhere from 6 months to 12 months. With the new requirements for adjustment of status forms, what does it mean for someone who may have gotten Medicaid assistance when giving birth? So this is a more complex question, but usually this is for individuals. So the Medicaid, giving birth, the Medicaid is not necessarily one of the covered benefits for purposes of the public charge rule. What they are looking at is, have you taken out any public benefits like cash assistance, or have you taken out any long-term care assistance? However, go ahead and make sure you are represented, and make sure you're getting legal advice. You can always contact the office and schedule a consultation, and we can look at your particular circumstances and answer. Now, this Medicaid for you to give birth, that was for you. However, when you also have your children, US citizen children, and you get public benefits on their behalf, that does not mean that you're subject to the public charge rule. So, can I travel to a USA territory island if I am out of status in the USA? So, when it comes down to travel, it's not a one size fits all question. Just because the risk is always high for anyone who is undocumented, or it's always higher for someone who's undocumented who's traveling by air. It could make it worse if you leave the US mainland to go to a territory. I have seen undocumented individuals travel without a problem to territories outside of the US, but it really comes down to your particular situation and what's going on. For instance, you might be doing that and you don't even know you have a deportation record, that you have been deported or there's an order of deportation out on you. And if you do travel and then you end up in a situation where they find you and find that order, it could mean that you don't get to get back into the US or onto the US mainland. Those are just some of the things that could happen. There's a low risk, but it's still there. And whether it's advisable for you to do that as an undocumented immigrant is really on a case by case basis. So this is why I advise my clients on a case by case basis. Whenever I get my clients their travel document, I have a meeting with them, or I contact them to be able to advise as to whether I think they should travel, because I know their case, I know their history, and I say, okay, the risk is low, but I think you're good, or no, I don't think it's worth the risk to travel. So that is definitely going to be a question for your attorney or in a consultation. With a marriage-based green card application, just being on a lease important to be submitted as a part of proof of bona fide. It's good evidence. So yeah, you want to be able to show that you are living together, because as and a joint lease alone isn't proof that you're living together. It's definitely good proof, but it's not the only type of evidence that you can use to show that you're living together. It just depends on your living situation. But hey, anything that shows that you're living together as a married couple is going to be valuable, helpful evidence for your marriage based process. Is it okay to retain you even without having an active case, like just in case something happens? So, I don't usually accept clients without matters, but it depends on what the situation is. It could be to advise you. That is the purpose of the consultation. So, the first thing you can do is speak with me in a consultation, and I can determine what your current situation is, advise you, and then you can decide how you want to move forward from there. And who knows, in the consultation, you may just find out that you qualify for something, because I've had many of those consults with people who are now my clients, where they just want to know their rights, they just want to know what their options are in the future, and it turns out they do qualify for something. How soon after marriage can you apply for adjustment of status? So right away, there's no rule that says you can't apply right away, but is it advisable to apply for adjustment of status right after marriage? That's the question. And this is where I see a lot of people end up in a very messy marriage based application. because they jump straight to just marrying and then filing the paperwork because they just think this is paperwork. I'm just going to fill it out and send it in and we'll see what happens. And what they see happens is not great. It is a process where you have to be very thoughtful, you have to be very intentional, and you have to make sure that you will prepare. If you want great results, make sure you prepare a thorough application from the beginning, because that's going to set the tone for the rest of your marriage-based process. So when I say, is it advisable to file the adjustment of status right after you get married? It's going to depend on the couple. So if you say you met Friday, you eloped on Saturday in Vegas, and then by Monday you're filing the paperwork. I wouldn't advise that because at that point, do you have anything in order? You got up, you got married, and then you filed. Can you show that you're living together? What can you show to show your intention that you plan to spend your lives together? What can you show to show your relationship, the timeline of your relationship? So in that case, you should take your time, make sure you figure out your options first, how you should approach that. And that's what I help my clients to do. First, we start with the consultation, and then I represent my clients through the preparation process, the filing process, and actually getting all the way to permanent residence. But on the other hand, say you have been a married couple, say you were together for a long time, say 2 years before you've been together, you guys have lived together for a while now, and you're like, let's get married. And you can show all of that you have been living together, that you married 2 years after you met, that you have had the intention to spend your lives together, and then you get married and then you file the next day. I have done that for my clients where we filed right after. I just sit waiting for that marriage certificate to come, and as soon as it comes, it's out the door the day after they get married. So yes, you can do that, but it's going to depend on the couple and what the application is going to look like. What are examples of proof that can be submitted is a case where we'd have to wait for the next renewal, which isn't anywhere close. So go ahead, schedule an appointment, and we can talk. No, examples don't, there is not a one size fits all. And an example is not necessarily going to fit your situation. So that's where an appointment is going to be very important. So I send my VAWA case 11/22/2022. I get the I-797C a few days ago for fee waiver accepted. When do I get the prima facie letter? So I've seen the prima facie anywhere from 2 to 6 months after filing. What if I have a pending VAWA case and they sent an RFE of living together and I cannot obtain that because there wasn't any joint paper trail documents, but we have pictures, etc. in the home? Then it means that you have a problem and you need legal advice. These are difficult problems that I tackle with my clients because it is a complicated issue, right? Especially when you have an unbalanced power dynamic where the home is maybe the home of the abusive spouse, or spouse or parent or child, or they will not allow you to go on the lease because control is very much a part of this type of mistreatment. And so you have a problem if you cannot show that you lived with this person. But even though I'm saying you have a problem, it's not to say it can't be solved. But when I am resolving that issue for my clients, we tend to we tend to get very creative with the way that we can submit this type of evidence. And it comes down to, once again, your circumstances and what was involved to be able to brainstorm about the appropriate evidence. And this is what I do for my clients when I'm representing them. I was approved for I-360 in December 2022. When can I get the green card? So if you apply for adjustment of status at the same time, they're going to schedule your interview. Or if they don't have any questions about your eligibility, you could very well get your permanent residence in the mail. But they are going to go ahead and schedule that interview, and you could be looking at another 6 months to a year to get to that interview. Can you do an adjustment of status for yourself without getting married? No. Now, I spoke about this issue this morning, and with someone. And when you come to the US and you want to get your permanent residence, you can't just come here and as long as you're here, you're going to get it. You have to make sure that you qualify in some way for adjustment of status. Do you have a relative other than a spouse who can sponsor you? Do you have an employer who can sponsor you? And is it going to be an appropriate filing through an employer? You have to make sure you're meeting all the requirements in the employment-based petition process. And then also there are humanitarian-based ways. So, getting asylum, the T visas, victim of trafficking. If you have the U visa, then you could apply for yourself eventually, but you first have to go through getting asylum, getting the T visa, getting the U visa. So, it all depends on how you qualify. So my husband got deported from the States 10 years ago. We've been married 8 years and have 3 kids, but we've been living apart 6 years, him in France, me in the States with the kids. We want to get him here in the States as it's a hardship raising the children without him. So this is what I help couples with. There is definite now, there are waivers available. Now, whether your husband is even inadmissible anymore is going to be dependent on the reason for the deportation. And this is a complex matter, but it is one that I do help clients to get to, and I help clients to get to the right result. So the first thing you have to do is schedule a consultation, preferably with your spouse involved. I do video and phone consultations where we can talk about what happened and then what if there's a waiver available to assist. You did mention hardships raising the children. So we can talk about what those hardships are and then present that case. Should you decide you want to move forward, we can always, present that case to the USCIS. All right. That's going to be it for me today. Thanks so much for your time. Thanks for your patience as I experienced some problems with the sound. I will be back tomorrow as usual, so you can always join me tomorrow and you can always bring your questions and I will bring my topic and we can dram it out. And then I see one more question that I just can't resist. So joint tax, what if you're here couple months but decide to stay and do adjustment of status? So I'm not sure where the joint tax comes in, but that is acceptable for some couples. I'm not saying you should do it. You need to make sure you get legal advice before you decide to stay and do adjustment of status because it can actually mess you up and complicate your process if it's done incorrectly. So schedule that consultation. And let me tell you this is how you get in touch with me. Go to the link in the profile and you will see the link. Click on the link and it's going to take you to the different, a website with different buttons and you can schedule your own appointment or you can go to the website. If you go to the website, you'll be able to see see the phone number, to see contact form, to see online chat. All three lead to the scheduling coordinator, and they would be more than happy to assist you on YouTube. If you look in the description of this video, you'll see everything you need to access the link and also to call the number. And you can always also see the contact number on the screen as well. So plenty of ways to get in touch. I will be back tomorrow. Thanks again for all your time. I appreciate it. See you tomorrow. Bye bye.